Procedural law or adjective law comprises the rules by which a court hears and determines what happens in civil lawsuit, criminal or administrative proceedings. The rules are designed to ensure a fair and consistent application of due process of fundamental justice to all cases that come before a court. Substantive law, which refers to the actual claims and defenses whose validity is tested through the procedures of procedural law, is different from procedural law. In context of procedural law, procedural rights may also refer not exhaustively to rights to information, rights to justice, rights to participation, which those rights encompassing general civil and political rights. In environmental law, these procedural rights have been reflected within the UNECE Convention on Access to Information, public participation in decision-making and access to justice in environmental matters, known as the Aarhus Convention. Legal procedure. Although different legal processes aim to resolve many kinds of legal disputes, the legal procedures share some common features. All legal procedure, for example, is concerned with due process. Absent very special conditions, a court cannot impose a penalty, civil or criminal, against an individual who has not received notice of a lawsuit being brought against them, or who has not received a fair opportunity to present evidence for themselves. The standardization for the means by which cases are brought, parties are informed, evidence is presented, and facts are determined is intended to maximize the fairness of any proceeding. Nevertheless, strict procedural rules have certain drawbacks. For example, they impose specific time limitations upon the parties that may either hasten or slow down the pace of proceedings. Furthermore, a party who is unfamiliar with procedural rules may run afoul of guidelines that have nothing to do with the merits of the case, and yet the failure to follow these guidelines may severely damage the party's chances. Procedural systems are constantly torn between arguments that judges should have greater discretion in order to avoid the rigidity of the rules, and arguments that judges should have less discretion in order to avoid an outcome based more on the personal preferences of the judge than on the law of the facts. Legal procedure, in a larger sense, is also designed to affect the best distribution of judicial resources. For example, in most courts of general jurisdiction in the United States, criminal cases are given priority over civil cases, because criminal defendants stand to lose the freedom, and should therefore be accorded the first opportunity to have the case heard. European history and concepts. Procedural law and substantive law in various languages. Procedural law, in contrast to substantive law, is a concept available in various legal systems and languages, similar to the English expressions of the Spanish words derecho adjetivo and derecho material or derecho sustantivo, as well as the Portuguese terms for them, direito adjetivo and direito substantivo. Other ideas are behind the German expressions formals recht and materials recht, as well as the French droit formal, droit material, the Italian diritto formal, diritto material, and the Swedish formal rat, material rat, all of which, taken literally, mean formal and material law. The same opposition can be found in the Russian legal vocabulary, with for substantive law and for procedural. Similar to Russian, in Bulgarian means substantive law and is used for procedural. In Chinese, procedural law and substantive law are represented by these characters and. In Germany, the expressions formals recht and materials recht were developed in the 19th century, because only during that time was the Roman actio split into procedural and substantive components. The substance of procedural law, substantive law, in Europe. In the European legal systems, the Roman law had been of great influence. In ancient times, the Roman civil procedure applied to many countries. One of the main issues of the procedure has been the actio. In the procedure of the legis actions, the actio included both procedural and substantive elements, because during this procedure the praetor had granted or denied litigation by granting or denying, respectively, an actio. By granting the actio, the praetor in the end has created claims, i.e. a procedural act caused substantive claims to exist. Such priority is contrary to what we think of the relationship nowadays, but it has not only been an issue of priority and whether the one serves the other. Since the actio had been composed of elements of procedure and substance, it was difficult to separate both parts again. Even the scientific handling of law, which developed during medieval times in the new universities in Italy, did not come to a full and clear separation. In Germany, the unity of procedure and substance in the actio definitely was brought to an end with the codification of the Bürgerliches Gesetzbuch, which came into force on January 1, 1900. The expression Anspruch, meaning claim, has been cleared from procedural elements, and this was the time for founding the terms formals, materials recht. However, after World War II, the expression formals recht obviously was found to be contaminated, and to a broad extent has been replaced by process recht, narrowing the idea behind it to law of litigation.